The following modules were developed as a community service in partnership between the Unified Government of Wyandotte County and the Housing and Credit Counseling, Inc. of Topeka, Kansas, HCCI. A series of 6 modules were developed by HCCI to address frequent and regular community issues that arise in the landlord-tenant arena. The 6 module topics include leases, security deposits, notices, evictions, move-in and move-out inspections, and renters' rights. All information discussed in the Landlord Tenant Modules can be referenced in the Kansas Residential Landlord and Tenant Act, or the KRLTA. To learn more about HCCI and HCCI services, including landlord tenant information, publication and forms, or if you need to speak to a landlord and tenant counselor, please call 785-234-0217 or go to www.hcci-ks.org. Module 2, Notices. Under the Kansas Residential Landlord and Tenant Act, notices, you need to know what kind of notices landlords and tenants must give each other. What types of notices are there? What happens after notices have been served? Kansas law generally recognizes delivery of notices when they are handed and delivered to a person that's over 12 years of age who lives at the person's address, or a notice can be posted in a conspicuous place at the person's address, or a notice can be mailed to the person's address or last known address. These are the different types of notices. Tenant notices to landlord. These are what tenants give to the landlord. It could be a 5-day landlord failure to deliver notice as defined in KSA 582560. It could be a 14-30-day notice of noncompliance under KSA 582559. It can be a notice of landlord entry under KSA 582557. It can be a 5-day notice of casualty under KSA 582562. It can be a 30-day notice of termination under KSA 582570. Or it can be a request for return of security deposit as defined in KSA 582570. We'll begin with a 5-day landlord failure to deliver notice as defined under KSA 582560. If your landlord fails to deliver possession of the dwelling unit to the tenant as provided under this statute, rent will abate until possession is delivered, and the tenant, upon at least 5 days written prior notice to the landlord, may terminate the rental agreement, and upon termination, the landlord shall return his security deposit. Or the tenant may demand performance of the rental agreement by the landlord, and if the tenant elects, maintain an action for possession of the dwelling unit against the landlord or any person wrongfully in possession and recover the damages sustained by such tenant. This is language from the Kansas Residential Landlord Tenant Act. Basically what it says is the landlord, if he says the dwelling will be ready by such and such a date and it's not, then this is when this notice kicks in and allows the tenant to back out of the agreement that was made within 5 days of that agreement. The second notice is a 14-30-day notice, non-compliance by the landlord under KSA 582559. The tenant may deliver a written notice to the landlord specifying the acts and omissions constituting the breach and that the rental agreement will terminate upon a periodic rent-paying date not less than 30 days after the receipt of the notice. If breach is remediable by repairs and landlord adequately initiates a good faith effort to remedy the breach within 14 days after receipt of notice, the rental agreement shall not terminate. Basically what this is saying, it allows tenants to serve notice under this 30-day notice to the landlord that says, Mr. Landlord, you must fix this, or this maintenance in 14 days. Otherwise, I will terminate my lease in 30 days. Now, if the landlord does remedy the situation within 14 days, then the lease shall not terminate. Other notice of termination is the 30-day notice of termination as defined under KSA 582570. The landlord or tenant may terminate a week-to-week tenancy by a written notice given to the other at least 7 days prior to the termination. This is a week-to-week, so you're giving people a full week to terminate the notice in the agreement that you have. Under B, the landlord or tenant may terminate a month-to-month tenancy by a written notice, stating that the tenancy shall terminate upon a periodic rent-paying date not less than 30 days after receipt of notice. So when your rent is due 30 days after, if you want to leave or break your lease, you have to give your landlord 30 days. The 5-day notice of casualty under KSA 582562 is another notice that tenants may serve to their landlord under these circumstances. If the dwelling unit is damaged or destroyed by fire or casualty to an extent that the use and habitability of the dwelling unit is substantially impaired, the tenant under 1 may vacate the premises immediately and notify the landlord within 5 days thereafter in writing. Or 2, if continued occupancy is lawful, the tenant may continue to vacate any part of the dwelling unit rendered unusable. Tenant's responsibility for rent is reduced in proportion to diminution. If rental agreement is terminated, the landlord shall return that portion of security deposit, and that is recoverable by the tenant. So the 5-day notice of casualties is under those circumstances where there's a fire or flood or something that just destroys the rental unit and habitability is just not possible. Another notice that tenants give the landlords is this notice of landlord entry under KSA 582557. Under A, the landlord shall have the right to enter the dwelling unit at reasonable hours after reasonable notice to the tenant in order to inspect premises, make repairs, decorations, alterations, or improvements. So under A clearly states the landlord does have the right to enter his property, but he has to do so in reasonable hours and give proper notice to the tenant. Landlord may enter under B. Landlord may enter without consent in case of extreme hazard involving potential loss of life or severe property damage. So under B, clearly it states the landlord may enter without consent when there is a fire, a hazard, or potential loss of life or severe property damage. Under C, it clearly says the landlord shall not abuse the right of access or use it to harass a tenant. So it protects the tenant from abuse of landlord entry. Another notice that tenants use quite often is a request for return of security deposit. Under KSA 582550, it states a landlord shall return the balance of security deposit to the tenant and in no event to exceed 30 days after termination of tenancy. So basically what it's saying is that the landlord Upon termination and proper notices given that termination is going to happen and everybody is okay with their leaving and ending their lease, the landlord has 30 days to return their security deposit. Landlord notices to tenant. Just like the tenant to the landlord and the notices that they give to the landlord also can give notices to the tenant. Under the statute, the landlord may give the tenant and serve the tenant with a 14 30-day notice of noncompliance under KSA 582564. Also, landlords can give a 3-day non-payment of rent notice, or otherwise known as an eviction notice under KSA 582564. Also, landlords can give a 30-day notice of termination under KSA 582570. Regarding the 14 30-day notice noncompliance by tenant as defined in KSA 582564, it states that the landlord may deliver a written notice to the tenant specifying acts and omissions constituting breach, and that the rental agreement will terminate upon a date not less than 30 days after receipt of notice if breach is not remedied in 14 days. So basically, what this is saying is the landlord can give the tenant 14 days to correct any breach that is found in the rental agreement, or the tenant has to be out in 30 days, the 14 30-day notice. Now, if the tenant corrects the noncompliance issue, then the whole point is moot and the landlord is satisfied. So if you're out there and get a 14 30-day notice, then know that you have 14 days to comply with your landlord's request, or he has a right to get you out of there in 30 days. Another notice by the landlord will be the 3-day notice to vacate for non-payment of rent under KSA 582564. Kansas law says the landlord may terminate the rental agreement if rent is unpaid when due and the tenant fails to pay rent within 3 days or 72 hours after written notice by the landlord of non-payment and such landlord's intention to terminate the rental agreement if the rent is not paid within such 3-day period. Basically, under the 3-day notice to vacate for non-payment of rent, this is an eviction. Under the law, once the landlord puts notice on your door or hands it to somebody that says you have 3 days or 72 hours to vacate, that is the first step to eviction. You want to reference our eviction module to learn more about evictions and the process of evictions. But under the 3-day notice to vacate, the landlord starts that eviction process by first putting notice on your door or handing it to you saying that your rent is due, and if you don't pay in full within 3 days, I have the right to evict you. So that is basically what a 3-day notice to vacate for non-payment of rent will do. Next slide is an acceptance of late rent. Under KSA 582566, under the law, it says landlords may accept late rent from the tenant without reservation by landlord, constitutes a waiver of landlord's right to terminate agreement for that breach. So basically, it is saying that if the landlord accepts your late payment of rent, he is no longer going to terminate or break the lease by using late rent as an excuse. We talked about the 3-day notice to vacate for non-payment of rent. This is the beginning of a process, and the eviction process, the notice of eviction process, And the statute says landlords may terminate rental agreement if rent is unpaid when due and tenant fails to pay rent within 3 days after written notice by landlord for non-payment. The process starts and it begins. The landlord begins with a 3-day pay or vacate notice. It's placed on your door. From there, the landlord files a case in district court to have an eviction proceeding started. The court then takes action which only they can take, and only courts can legally evict. If the judgment is for the landlord, the court will order the sheriff's department to carry out judgment. If the landlords do not follow this process, then you have an eviction with no court action. An eviction with no court action is unlawful removal, self-help eviction, and also constructive eviction. That includes lockouts, removal and holding of personal property, interference with services and utilities, and interference with access, threats, or force. Eviction with no court action is unlawful. Landlords cannot lock you out, cannot hold your personal belongings as hostage. They can't interfere with your utilities, cut your water off, your electricity. They can't do that. They can't nail your door shut, interfere with any access, and they cannot be threatening or forcing their will on you. Unlawful removal under KSA 582563. If the landlord goes this route, unlawful removal, the tenant may demand possession of the dwelling, terminate the rental agreement, in either case recover actual damages or 1 1/2 times the periodic rent amount. They can call the police. They may intervene for the tenant, and the tenant may file charges against the landlord. Notice of Abandonment of Lease, KSA 582565. Extended absence of tenant, damages, entry by landlord, abandonment by tenant, when reasonable effort to rent required, termination of rental agreement, when personal property of tenant, disposition, procedure, proceeds, and rights of person receiving property. Notice of Abandonment of Lease under KSA 582565. What does that mean to the landlord? If he thinks the property has been abandoned, he's noticing that there has been a substantial portion of belongings removed and the tenant has not given any notice that they have left. Now, substantial portion of belongings removed. What if a person only has a few things and it looks empty? Is that enough for the landlord to go in and claim abandonment? I don't know. That is a court decision. Abandoned property and the landlord's gain possession. Under KSA 582565, tenant who abandons or surrenders a rental unit leaves behind personal property. Possession is returned to the landlord by court action. Tenant's personal property is still in unit. What happens when these are the cases, when these are the scenarios? Abandonment under KSA 552565, a landlord must store a tenant's personal property for 30 days. Landlord must publish an ad in the newspaper 15 days before disposal of property. Landlord must send copy of ad to the tenant at last known address within 7 days notice appears in the paper. Landlord releases property, tenant can pay before disposal date, and the landlord must release secured property to legal owners. For example, rent a center, what have you. What are landlords required to do regarding disposal of personal property under KSA 582565? Well, a landlord may keep it, sell it, give it away, or just flat out just throw it away. Any questions that you may have regarding notices and the number of notices and where and when, please call the Housing and Credit Counseling Incorporated at 785-234-0217 or go to our website at www.hcci-ks.org.